case on this morning's docket. Case number 115650, John Balburney v. State of Kansas.
Morning, Chief Justice. My name is Gerald E. Wells. I represent the petitioner appellant in this matter, Mr. John Balburney, and I would request 3 minutes rebuttal.
3 minutes is granted.
Judge, we are here today for oral argument on a petition for a review of the Court of Appeals decision denying Mr. Balburney's appeal of a district court decision, which in turn denied his 60-1507 motion alleging ineffective assistance of counsel. As the court is aware, and we've included it in our petition for review, this is a very narrow issue. It is also undisputed that we are here to discuss the second prong of Strickland because the Court of Appeals found that counsel was ineffective. And so with that, it limited us, and appropriately so, to a discussion of the second prong of Strickland. Further narrowing our issue this morning is whether or not a tape, a 9/11 tape, should have been introduced by counsel. And is that sufficient to show that there would have been a probable different outcome had that tape been into evidence? Or, saying it another way, did it undermine the result of that trial? It is our position that it did, unequivocally. And I think it's important to begin with, if I may, read the translation of the tape itself. I listened to this tape at this courthouse at least a dozen times, and although the district court and the Court of Appeals thought that it was jumbled and it wasn't easily understood, there are a number of things that came out of that tape that are easily understood and very clear. And let me hit that. The call comes in to dispatch, 9/11 call from Teresa Brown, who's one of the people that's there when this occurred. And she said, although very excited, obviously.
How contemporaneous is it with the action that is occurring?
It's very contemporaneous, Judge.
Okay, thank you.
She's hysterical almost. And she says, they stabbed each other. They stabbed my fiance. And during the interim, they're trying to get information out of her as to what happened. And the dispatcher says, who stabbed your boyfriend? She ran downstairs, in her words, doesn't know. And then she says, dude tried to hit me and my fiance stopped him and he's laying here. But the final statement that I think is most important here and is a game changer in my view, my fiance stabbed him and he's laying right here.
Mr. Wells?
Yes.
When was that transcript produced? The transcript of the call?
I think early on, Judge or Justice Beyer, but I think there was opportunity for both counsel and whoever had the authority to do so to listen to that. But the reason it wasn't introduced, and here's where the ineffective part comes in, trial counsel assumed that the state would introduce that tape. I don't think that's reasonable. I don't think there was a chance in the world that the state was going to introduce that kind of evidence. But he didn't lay a foundation because of that, didn't subpoena the kind of people that he needed to subpoena to get the thing admitted into evidence.
And he also didn't ask Brown herself about it, right? She testified at trial, didn't she?
Yeah, she did.
And he didn't attempt to impeach her testimony that was...
Well, he did, in sort of a way.
But did he mention the 911 call and trying to impeach
Yes,
her?
yes.
Did he ask her about the specific statement of my fiance stabbed?
I think that's true, but she worked her way around it. She wasn't direct with it. And that's why I think that this particular tape undermines the confidence in the outcome and you'd have a different outcome.
Counsel,
Yes.
wasn't there other evidence from witnesses who said, no, Mr. Wallace, the fiance, never stabbed anybody?
I'm glad you brought that up, Chief Justice, because the Court of Appeals glossed that over. The two witnesses that testified against Mr. Balburney were co-defendants, and they cut a deal with the state. Now, it's also important to recognize that these people were connected. Paul Wallace was Miss Brown's fiance. The other, Elsmore, was her cousin. So you could reasonably suggest that there was an agreement that Mr. Balburney was the odd man out and he ought to take the fall for this.
But didn't Wallace say that Balburney was essentially his father? He thought of him as his father.
I didn't hear.
Wasn't there evidence that Balburney, or that Wallace testified that he thought of Balburney as his father?
There was, but he also said that he didn't stab anybody. In the prelim, he said that, and in the trial, he said that. So what we have here...
Let me make sure I know.
Sure.
Him you're referring to, Wallace said that
Yes.
he didn't, meaning Wallace himself didn't stab anybody.
Right, right. And that's in the transcript of the 1507 hearing. Now, why this is important, and I think it's important to recognize the character of this evidence. If you're in my world of criminal defense, and if it's favorable, you don't get any better evidence than this because it's real time. It is what it is. It's not given to twisting around. It's not given to conjecture. So it's also very dramatic evidence to a jury. And that's what this was. Secondly, it directly contradicts the testimony that he did not stab Mr. Nicholson, the victim. That's contradictory because Ms. Brown says, my fiance stabbed him. As opposed to Wallace saying, I didn't stab anybody. Now that's exculpatory evidence and should have been in front of the jury. And it's exculpatory evidence that this jury should have heard because I think it's the game changer. If you have that kind of evidence and it's not in front of a jury, that puts that jury at an extreme disadvantage of hearing all of the evidence, and it certainly puts Mr. Balburney in a disadvantage without that evidence in front of the jury. Again, it directly contradicts the Wallace testimony. It is real-time, in-your-face kind of evidence that you love to have if it's favorable. And it's favorable. But counsel failed to get that in front of the jury. It wasn't a matter of strategy. I don't know what strategy you could concoct that would allow this tape not to go into the jury. That was the basis of the first prong finding that trial counsel was ineffective and violated his right to a fair trial. So I would say to you that it did undercut and undermine the result because that evidence which was crucial was not in front of the jury and should have been. So we're asking for a new trial and for that tape to be admitted into evidence as contradictory and exculpatory evidence and grant a new trial.
This court can't direct that it be admitted into the record. A foundation's got to be laid for it at a new trial.
That's true.
And how do we assume that a foundation could be laid for it? Brown is deceased.
Well, there are avenues to admit that kind of a tape.
Well, but how? Why must we assume that the trial judge on remand would find one of the well-recognized hearsay exceptions and let it in? Why must
You
we
can't assume that. You can't assume that. But what you can do is grant a new trial and give them the opportunity, Mr. Balburney, the opportunity to make that argument. And it's a good argument because it's relevant evidence. It's exculpatory evidence. So I don't think, to answer your question, I don't think you can guarantee that. No one can how a judge is going to rule. But it's there, and you can make that argument because I think it's a good one.
Any further presentation?
No, Judge.
Do we have any more questions? Thank you, counsel.
Thank you.
May it please the court, counsel. On behalf of the state of Kansas, I'm Brandon Jones, the Franklin County Attorney.
Counsel, I'd just like to go back to my original question to your opposing counsel. When was the transcript of the 911 call produced?
I don't know the answer to that. I don't.
So
think
it was introduced in the 1507 hearing.
That's correct. It was
But
not. It was not available at the trial, is my understanding.
It was not available at the trial.
Correct.
Okay, that's what I want. I was trying to pin that down
Yeah, it
to
was-
understand whether, because the judge relied in part on the actual tape being difficult to understand.
Correct.
Okay, thank you.
Both in the state's position today, this is an extremely narrow issue, as opposing counsel pointed out, and it's whether or not the lack of the omission of the 911 call was an error by the defense attorney, which has pretty much been decided by the Court of Appeals, and then more importantly, whether it meets the second prong of the Strickland test, whether there's prejudice and resulting in the need for a new trial. Both the district court and the Court of Appeals were correct in dismissing the appellant's appeal, alleging the effective assistance of counsel during the second-degree murder trial. The Court of Appeals noted in their decision that the trial attorney made one significant error. It's just one error we're looking at, and that was failing to get the tape admitted into evidence. That is that the caller said her fiance, who was Philip Wallace, stabbed the victim. The Court of Appeals noted in their decision that that would have been important evidence to present to the jury. Defense counsel in the 60-1507 pretty much conceded that as well. He did say that he wished that the jury could have heard that. He expected the state to introduce that evidence. When the state did not, he had not subpoenaed the proper witnesses and therefore didn't try to move to admit it.
And so
what
based on
happened?
that,
Excuse me. Go ahead.
based on that, do you agree that there was, the counsel fell below the standard?
The Court of Appeals stated that, and
And you have not cross-appealed?
I have not, and I'm not going to try to challenge that.
Cross-petitioned, I mean.
In my opinion, as an attorney of 20 years' experience in doing several jury trials, yes, I think that that's a tape that should have been admitted into evidence by the defense in an attempt to try to present another theory. I think it should have been admitted. I think that that does probably fall below the threshold.
So we're just
Speaking-
here to talk about the second Strickland.
That's
call.
correct.
All right.
And
Sorry.
speaking of that, speaking of the prejudice prong, what happened during Brown's testimony in terms of what the defense attorney did or did not succeed in doing re the tape? Did it get mentioned at all? Let's start at the baseline.
The 911 call got mentioned. I don't believe that the defense attorney directly cross-examined her on the contradictory statement.
Okay.
He did
on
not-
the on the nut of the call, what the
Correct.
defense should have wanted in. Okay, that's what I
Correct.
was. It sounded like your opponent may have made a concession on that, and I wanted to clear that up.
I like that concession, but in my reading of the transcript is different. That he did not actually ask the ultimate question. Well, didn't you say on the 911 call that your fiance stabbed the defendant? Today, you're not saying that.
Okay.
He did not ask
She
that
didn't
question.
get impeached. Okay.
She did not get
that
impeached on that. She did get impeached on other things,
I
but not
understand.
that.
That's what I wanted to know. Thank you.
So there are 3 witnesses who testified that it was not the fiance.
Yes, Your Honor.
And
That's
wasn't there serious credibility issues with each of those witnesses?
I'm not going to go that far. The opposing counsel said that both Wallace and Ellsmore were co-defendants. And unless I read it wrong, I don't believe that's true. Mr. Ellsmore was also admitted to and was charged with stabbing the victim in the back. He admitted to that, and he took a plea to that, pled to an aggravated battery, and went to prison. So he was a co-defendant.
But didn't he early on tell the police there was no reason for them to look at this defendant in this murder? And then later change his story to say, oh, I saw a shiny object that might have been a knife. And then at trial changed it yet again and said, oh, he stabbed him. So doesn't that create a serious question about his credibility?
There are witness credibility issues, but that's for the jury to decide, and they were able to reach those
So
conclusions.
why does Teresa Brown's statements not weigh on not only her own credibility when she said her fiance didn't have a knife that day, but also on Elsmore's credibility and probably even Wallace's credibility?
So all three of the eyewitnesses to this event, other than the petitioner, testified. All three of them testified that Philip Wallace did not stab the defendant. All three of them testified that the petitioner did stab the victim. On top of that, in the statement, she said at first they're stabbing each other. The evidence is very clear that only one person was stabbed, so that wasn't correct. She also said, my fiance got stabbed. That was not correct either. He was not stabbed. So she was excited. She was concerned. If you actually listen to the tape, her primary concern was for her child. She had a young child, and she said, my baby. That was her primary concern.
And that's all jury argument for when this evidence came in.
Correct.
In
Right.
context, doesn't it become clear in the call that my baby probably referred to her fiance? Maybe it was a pet name for a fiance?
That's not how I took it. I've listened to it, and no, I think she was talking to her about her actual child. She was concerned about the safety of her child because she had 3 grown men in her apartment that were engaged in a fight, and knives came out, and there were at least 2 people that stabbed him, and the victim had fallen out the window and was laying in the yard. I think she was concerned about the safety of her child. So my point being that there were 2 statements that she made on that call that were not supported by the evidence. So what we want to now say that the 3rd statement, that my fiance stabbed him, despite all the other evidence to the contrary, that would somehow change the outcome. And the state would argue it doesn't. First of all, it's point out it is the defendant's burden to prove this. He carries the burden in this case. And the reasonable probability has to be sufficient enough to undermine the confidence in the outcome. He bears the burden, and bears the burden of establishing the record as sufficient to support his claims. So looking at the totality of the evidence, I do want to talk about it. All 3 of the eyewitnesses to this incident testified. Teresa Brown testified first. She said that Elsmore stabbed Nicholson in the back. Elsmore acknowledged that and in fact pled guilty to that and went to prison for that. She also testified that the petitioner stabbed the victim twice in his right side of the back. And she then left to make the 911 call. She wasn't there when what the other 2 witnesses testified was the crucial, the death blow, which was the shot to the chest. But she did hear the petitioner state out loud, I got him. So she heard the petitioner acknowledge stabbing the victim. Philip Wallace also
When was
testified.
the first time she told police that?
They were all separated and interviewed that night.
And don't Elsmore's version and Wallace's versions of when the fatal blow, where it even occurred and how it occurred, don't they differ totally?
Elsmore said that the petitioner stabbed him in the chest upstairs, and Wallace said that it happened downstairs. That is correct.
And the motions and the number of stabbings, they both,
Right.
didn't Elsmore say the defendant stabbed the victim 2 or 3 times in the chest?
I believe that's true. Yes, I think it was twice actually, twice in the chest. He said he just did it twice. I will point out that obviously that this was a crazy situation. It was in a small apartment. There were 3 grown men. There was alcohol involved. Knives came out. The victim went down the stairway, basically fell down the stairway. 2 of the men proceeded down, including the petitioner. Then he went through a window and out into the front yard. There was a lot of commotion. Clearly not every single person had the exact same vantage point, and there was some conflicting testimony. But at the end, looking at the totality of the evidence, which is what this court's charged to do, you had all 3 eyewitnesses said that the petitioner is the one who stabbed the victim. 2 of those heard the petitioner admit to stabbing the victim. 2 of those eyewitnesses said that he stabbed him in the chest, which was medical testimony presented was the fatal blow. The other evidence, there was not just that. The petitioner, the defendant, had on a bracelet on his hand, the victim's blood. He had on his shoelaces.
A lot of them had blood on them, didn't they?
I think they did. It was
Including the
a
victim's
mess.
blood? Yeah, it was
Yeah,
a mess.
it was
I
a
mean,
mess.
the crime scene was a mess. Everybody had
Correct.
blood all over. Yeah, so that's kind of less than compelling.
In fact,
You're absolutely fulfilling your role here in trying to make sure you pile up on the other side of the scale. But would you agree with your opponent that short of a recorded confession by another person, that a contemporaneous eyewitness statement that someone else committed the crime is pretty Cadillac evidence for a defense lawyer?
I think it should have been admitted.
Yeah,
I think it
I
should have been.
understand you admit it was error, but it ranks up there at the top in terms of the type of evidence the defendant can muster, doesn't it?
It's an important piece of evidence. I'm not going to dispute that.
Yeah.
I just would argue that in the totality, there was plenty of other evidence out there to overcome that error.
I understand.
Essentially, that it's harmless error in this case, that it doesn't rise to requiring a new trial.
Justice Lickert, I'm sorry I interrupted you. Do you have something?
No, I actually forgot what the quote is.
I think that the
No,
one thing we're
that's
not
okay.
talking
It obviously
about
wasn't important.
is when the petitioner was in an interview room at the station, a detective pointed out he had blood on his shoulder too. The detective then walked out and he was on camera and he clearly didn't know he was on camera. He started trying to get that off quickly. He also was seen acting out a stabbing motion in that room, and then he made a statement.
Had the investigating officer told him about the stabbing before he did that motion while he was out of the room, or do you know?
I don't recall.
Okay.
I don't recall. He did make a statement then too. He said, "I hope I don't get told on. Just deny it, Philip. Don't blame me." That was played before the jury. That was argued in closing arguments, and I think that's a
This
pretty.
was Wallace in the next room.
Wallace was in the next room being interviewed, and it looked like he was clearly talking to his friend through the wall.
But didn't he also say, I just didn't do anything wrong?
Well, that's what he told the police officers, but to their face. But when he's in there in the room by himself, he says, "I hope I don't get told on. Just deny it. Don't blame me." Essentially saying, if we all stick together, stick to our guns, and deny it, they're not going to know who did this. But I think that was extremely compelling evidence to the jury. You couple that again with, and I understand it was a bloody crime scene, but the fact that he had victim's blood on his knife hand, on his shoelaces, the fact that all three witnesses testified that he stabbed the victim, that none of them testified that Philip Wallace stabbed the victim. All of that taken together, the state would argue, is enough that despite the fact that the tape should have been played, that it overcomes that and it wouldn't have changed the outcome. Unless there's further questions, I'm going to conclude with a quote that I think is important out of Strickland. In that decision, they said, in making a determination whether the specific errors, in this case error, resulted in the required prejudice, a court should presume, absent to challenge to judgment on grounds of evidentiary insufficiency, that the jury acted according to law. An assessment of the likelihood of a result more favorable to the defendant must exclude the possibility of arbitrariness, whimsy, caprice, nullification, and the like. The assessment of prejudice should proceed on the assumption that the decision maker is reasonably, conscientiously, and impartially applying the standards that govern decisions. The state would argue that the jury did that. They had sufficient evidence. If this other tape were played, it certainly would propose another alternative, but the evidence to the contrary was clearly overwhelming. And it's clear that on that tape, she said two other things at the start that clearly weren't true by the evidence. She was excited, she was scared, she wasn't in the best position to view the actual fatal blow, and she was most worried about her child.
Okay, but on that point again, the only reference I remember seeing in any of the briefing to a child was Elsmore's child, who they took, had been with them throughout the evening. I didn't see any other reference to a child. Can you tell me where that is in the record?
I cannot. I cannot.
But your understanding is that she had a child as well as
Yes.
Elsmore's child?
That she had her child there and that she was most concerned about her child. She thought something harm might fall to her child based upon what was going on in the apartment. And one last thing I'd say, you talked about contemporaneousness of the statement. It was extremely contemporary. It was as it was going on. But you can hear on the call, which is not a very long call, officers are there and you can hear them questioning the witnesses on the phone as it's being hung up. So the officers were right there contemporaneous too, separating the witnesses and getting their statements as well.
I did want to talk about the timing. There's a statement from Brown that while she was on the phone with 911 and after the police had arrived, Balburney came downstairs with a shirt and a beer and said, quote, "I stabbed the dude in the neck," unquote.
Correct.
How, do you know how soon after her call to 911 where she was very excited that that statement was made?
I think that was right after. You can hear her get off the phone with 911. You can hear that the police are there. So my understanding was that was extremely contemporaneous. It was right in the same time, the time frame as the 911 call.
All right,
That's
thank
my
you.
understanding. There are
Any
no
fur-
further questions?
Any further questions? Thank you, counsel.
Thank you.
Chief Justice, I would like to react to what was outlined by the state regarding a scenario in the jail where Mr. Balburney was observed to brush something off of his shoulder. My memory serves that there was no proof that that was blood, or wasn't blood, or was blood. So there's nothing there in terms of culpability because he brushed something off of his shoulder. That was an observation. Secondly, the statement that he made to Wallace through the wall was, the end of that statement was, "Don't blame me." Now that can cut both ways. That can cut, I didn't do it, and it also says, don't blame me just because the rest of us were involved. So that, the point of that, as far as I'm concerned, is the fact that that's doubles down on the reason why you need that tape information in front of a jury, because that just calls more question, and the jury should have that call because it's exculpatory, and it cuts both ways. Thank you.
I'm kind of curious, counsel.
Sure.
Brown, Wallace, and Elsmore all testified they heard Balburney admit stabbing the victim after the fact. And what was his response to that? That they're all lying or they're mistaken or what?
Well, no, his position was that I didn't stab anybody. I'm innocent. I mean, throughout this whole procedure. But that simply shows the difference between these statements and the testimony, and it was a mess at the time that they investigated this. That's, again, one more reason why you need every piece of evidence in there, exculpatory or not, so the jury can consider in reconciling all of those different stories.
All right, thank you, counsel. Do we have any further questions?
I've got one. I'm struggling with this, so, and if I've got the facts wrong, just you'll tell me. It seems to me that the error finding is parsed pretty finely. In other words, it's the failure to introduce the tape. But there's no finding of error for a failure to capitalize on what information was contained in the tape. In other words, the defense counsel could have impeached her saying, well, you said something different on a tape, or do you remember the tape? You don't need the tape to capitalize on the inconsistency in the testimony, correct?
That's correct.
And so when we're trying to figure out the prejudice, we should not try to think about how, capable defense lawyers would capitalize on the inconsistency by hammering it home, because he had that opportunity, but for whatever reason, no error was found there. So we really are just thinking about whether playing the tape to the jury would have tipped the balance, as opposed to playing the tape and then getting your sledgehammer out and pounding the table about what's on the tape.
Well, I
You
can't
see the
speak.
distinction? You see how I'm parsed that?
Yes.
Okay.
I can't speak for trial counsel as to why he didn't more deliberately attack Brown. That may have been part of his overall strategy, because recall, his strategy was essentially the other dude did it, and he also argued that there was only one drop of blood on his shoe, on Balburney's shoe.
But we don't have an error finding on anything other than just the failure to introduce and play the tape.
That's true.
That's all we have.
That's right.
That's a function of what you challenged, right?
Exactly.
You didn't also call defense attorney out on the failure to capitalize on what the content
No,
was.
I thought there was a direct line. I thought that in analyzing all of the possibilities, this just jumped out.
Yeah, I understand. But you just didn't make the further claim. That's why there's no holding on it from either the district
Right.
court or the Court of Appeals. Okay, thank you.
Any further questions of counsel? I see none. Thank you, counsel, for both your arguments this morning. Court will take this matter under advisement.